Hello everyone, I, Niti Singh from LL.B, welcome you all to the next legal update of MERI PLI Legal Bulletin. So, today's topic is media and censorship, freedom of speech versus hate speech in social media regulation. We live in an age where social media has become the modern day public square. With just one click, opinions spread across the globe, movements begins and governments are questioned. Social media has empowered citizens to speak up, but at the same time, it has also become a breeding ground for misinformation, hate speech, and online harassment. This gives rise to a very crucial legal dilemma, that is, how do we protect the fundamental right to free speech while also ensuring that it is not misused to spread hatred and violence. The Indian Constitution guarantees freedom of speech and expressions under Article 19 Clause 1A, but Article 19 Clause 2 clearly states that this right is not absolute. It can be reasonably restricted in the interest of sovereignty, integrity, public order, decency, and morality. The Supreme Court has time and again stressed this balance. In Shreya Singhal versus Union of India 2015, the court struck down Section 66A of the IT Act because it gave excessive power to authorities to silence online speech. The court made it clear that online speech which incites violence or threatens public order can be restricted. Yet, in recent years, the government has introduced new frameworks such as the IT Rules 2021. These rules place responsibilities on social media companies to remove unlawful content within a strict manner and time limit. While this aims to control fake news and harmful content, critics argue that it may also allow excessive government control and arbitrary censorship. The question is, who decides what is unlawful or harmful? The judiciary, the government, or the private companies? This grey area continues to spark debate. Globally, similar discussions are happening. The European Union has passed the Digital Services Act to ensure greater accountability of tech companies. In the United States, the debate over Section 230 of the Communication Decency Act continues. Should a platform be held responsible for user content or treated as neutral intermediaries? These examples shows that the challenge of regulation speech online is not unique to India. It is a global struggle. The real problem lies in drawing a clear line between free speech and the hate speech. Free speech is the lifeblood of democracy. It gives citizens the right to question authority, to protest, and to demand change. But when speech crosses into targeted hate, communal provocation, or incitement to violence, it can destroy the very fabric of society. This is why regulation is necessary, but it must be balanced, transparent, and subject to judicial oversight. Therefore, India needs a framework that doesn't silence voice in name of control, but ensures accountability in a way that strengthens democracy. What we need is not blanket censorship, but intelligent regulation, rules that protect citizens from online abuse and harmful speech without curbing the right to dissent. Because if freedom of speech is silenced, democracy itself becomes weak. As Justice Brandels of US Supreme Court once said, the remedy to false speech is more speech, not enforced silence. In conclusion, let us remember that freedom of speech is not just a constitutional right, it is the soul of our democracy. It must be exercised responsibly, protected carefully, and balanced wisely. Because silencing free voice means silencing democracy. So that's all for today. We will back with more new legal updates next week.